Welcome to the Environmental Essentials webinar for the month of September. I am Joe Brazauskas, a senior counsel for Bracewell's Policy Resolution Group. Looks like we've got a number of folks still filtering in. I'm just going to give it a minute or two and then kick off our presentation on the Congressional Review Act. All right, well, let's get things started. Once again, good morning, everyone, and welcome to the Environmental Essentials webinar for the month of September. I'm Joe Brazauskas, a senior counsel for Bracewell's Policy Resolution Group, and I'm here to talk to you today about the Congressional Review Act, give you a quick overview of what that law, the power that it bestows upon Congress, and then talk about some of the implications that we see for the upcoming Congress and into 2024. So with that, let's get started. So what is the Congressional Review Act? It originated as part of the Contract with America. It was part of the Small Business Regulatory Enforcement Fairness Act, or SBREFA, and it was signed into law by President Clinton in 1996, and it's codified at 5 U.S.C. sections 801 through 808. So it does a number of things. First, it requires federal agencies to report the issuance of rules to Congress and provides Congress with procedures to issue a joint resolution of disapproval of the rule. If signed into law by the president, or if vetoed by the president and overridden by Congress, the rule at issue is prevented from going into effect. So we've actually seen quite an uptick in the use of the Congressional Review Act since it was enacted back in 1996, and it's in fact overturned 20 rules, 1 in the 107th Congress, 16 in the 115th Congress, and 3 in the 117th Congress. And what makes the Congressional Review Act particularly powerful is the carryover provision. So this is really important for when there is a change in a presidential administration, and when rules that are promulgated by the presidential administration that's finishing its term in a certain window of time, it allows, and in fact, actually Congress to take a look at those rules into the next Congress with a new presidential administration. So this is when a rule is submitted to Congress within the last 60 days of a congressional session, and then Congress adjourns, and then there is a change in party of the presidential administration. So in fact, it actually gives that new Congress the ability to look back at these rules that are promulgated again at the end of a presidential administration with potentially a more favorable future presidential administration who would be more willing to approve and sign the disapproval motions into law. So we're going to first take a look at what does the Congressional Review Act define as a rule. So the Congressional Review Act actually takes the broadest definition of a rule from the Administrative Procedure Act. A rule is the whole or a part of an agency statement of general or particular applicability and future effect designed to implement, interpret, or prescribe law or policy. However, the CRA actually specifically excludes certain types of rules. So these are rules of particular applicability, rules relating to agency management or personnel, and rules of agency organization, procedure, or practice that do not substantially affect the rights and obligation of non-agency parties. So in fact, Congress cannot disapprove of those types of rules. However, Congress can, of course, disapprove. This is any final rule that is published in the Federal Register and reported to Congress. And so what does one of these joint resolutions of disapproval look like? They're very short. And in fact, the CRA actually tells Congress what that should look like. It just is a short, simple statement that says that Congress disapproves of the rule submitted by the agency relating to the name of the rule, and such rule shall have no force or effect. And that's it. These disapprovals do not have a long preamble. They don't give a lot of context. It's a very short statement. And one thing I want to point out here is oftentimes when discussing the Congressional Review Act, you hear the terminology of, quote, midnight regulations. So again, this is the concept of regulations that are promulgated, that are finalized and printed in the Federal Register at the end of a presidential administration. So, and there are two ways, in fact, actually, that these rules can be pulled back when there is a change in presidential administration. So generally speaking, midnight regulations are any rules that are issued within the last 60 days of a presidential administration. And these rules can be, quote, overturned by an incoming administration through the federal agency rulemaking process. In fact, we've seen historically that a new incoming president will have a regulatory moratoria on promulgating new rules, and in fact postpone the effective date of any finalized rules that are midnight regulations. And then this gives the federal agencies time to rewrite those rules and change the policies that were put forward by the previous administration. Proposed rules not published in the Federal Register at the end of a presidential administration as final rules can be withdrawn by the incoming administration. Now, and as we had discussed previously, the Congressional Review Act carryover provision, this is again for rules that are submitted to Congress at the end of a congressional session. They are given, and Congress goes out of session without having a full 60-day review period. That clock starts again in the new Congress under a new presidential administration. This also works as well if, for example, the presidential administration is the same as the previous one. However, when there is an alignment in parties between the president and Congress, that is what sort of gives more of the power to actually overturn and disapprove some of these rules. So the carryover period begins on the 15th in-session day in both the House and Senate. So that's when the clock starts again to get an entire 60-day review period once again in the new Congress under either a new or existing presidential administration. So again, particularly powerful when there's a change in the party of the presidential administration. So for example, as we're headed into an election year here in 2024, any rule that is finalized by the Biden administration within the last 60 days of congressional session, if there's a change in president, if it's President DeSantis or President Trump or whomever on the Republican side, Congress will have an extra 60-session day of review under a potentially Republican president to disapprove some of the rules that were promulgated by the Biden administration. Now, one other thing that the Congressional Review Act talks about is special requirements for major rules. So major rules are defined by the Congressional Review Act as any rule that OIRA finds has resulted in or is likely to have an annual effect on the economy of $100 million or more, have a major increase in costs or prices for consumers, industries, governments, or regions, or significant adverse effects on competition, employment, et cetera. So for these types of rules, Congress requires that the Comptroller General, that's the General Accountability Office, GAO, to provide reports to House and Senate committees of jurisdiction that assesses the procedural steps, the cost-benefit analysis, and other analyses. It also extends the effectiveness date of such rules to 60 days versus 30 days under the APA. So again, it takes 60 days for major rules to go into effect. So what happens when a rule is disapproved? Well, a joint resolution of disapproval is enacted if approved by both houses of Congress and signed into law by the president. If the rule had already taken effect, it goes out of effect immediately upon enactment, or if it had not yet gone into effect, it's immediately withdrawn. So how does this impact future rules? So if a joint resolution of disapproval is enacted, the rule, quote, may not be issued in substantially the same form, and a new rule that is substantially the same may not be issued unless the reissued or new rule is specifically authorized by a law enacted after the date of the joint resolution. So, in fact, it's a very powerful tool in that if a rule is disapproved, the federal agencies cannot issue the rule in substantially the same form. And this does present some interesting consequences. And just historically, 2 rules have been reissued that have been previously struck down by the Congressional Review Act. The burden is on the federal agencies to determine how the newly rewritten rules were not substantially the same as the disapproved rule. And in fact, in some of these instances, and in these 2 historical incidences, it's actually these were rules that Congress had prescribed via statute to promulgate. And so this is where it creates an interesting situation, because Congress told the federal agencies to promulgate a rule and in fact then disapproved the rule. And now the federal agencies have to determine how they can reissue that rule without it being substantially in the same form. And this does lead us to a discussion on what kind of judicial review is there for the Congressional Review Act. And in fact, there is no judicial review of the Congressional Review Act. So the law itself states no determination, finding, action, or omission under this chapter shall be subject to judicial review. So courts generally refer to the plain reading interpretation of the statute that, in fact, the CRA precludes judicial review, meaning they may not consider claims regarding an agency's failure to comply with the CRA, for example. Now, no court has ruled on the question of the substantially the same language that's contained in the Congressional Review Act. And so, in short, Congress has the final word on actions related to the CRA. Now, what I mean by that is I'm saying that in not sort of practical terms, but more in sort of the legal terminology. And if you think about some judicial opinions that say, well, Congress needs to act on this, or Congress needs to take a particular action here. They're the holder of this particular statute. And so what I mean is that if the federal agencies go back and reissue a rule, it's up to Congress to utilize the Congressional Review Act through the disapproval process to say, well, this is substantially the same rule, and you need to go back again to the drawing board. Courts are not likely to decide and have not ruled on this substantially the same language. Now, this does lead also to refer back to our discussion on what is a rule under the Congressional Review Act. And in fact, there have been instances where federal agencies have taken actions that they do not believe have to be submitted to Congress under the Congressional Review Act. And it's actually up to the GAO for Congress to ask GAO to provide an opinion to Congress on whether or not a federal agency should have sent the rule to Congress for review. And in fact, GAO does produce these opinions, and in many historical instances, what the House or the Senate does is they actually take the opinion, they enter it into the congressional record, and they can start the Congressional Review Act process based upon the GAO's opinion. And in that case, they do not have to wait for the federal agency to submit the rule to Congress. They can, in fact, take the opinion and from the GAO and move forward with it to take action. So let's take a look a little bit at some of the actual uses of the Congressional Review Act here in the 118th Congress, and then we will also take a look at what we think are some of the implications for the Congressional Review Act headed into 2024. So again, a joint resolution of disapproval is enacted only if signed into law by the president or overridden, if vetoed, overridden by the Congress. So 5 disapprovals were approved by both chambers of Congress and were vetoed by the president in the 118th Congress. So in fact, these are instances where the House and the Senate both passed a disapproval resolution, and those resolutions went to the president's desk where he vetoed them. And that's on the EPA heavy-duty engine and vehicle standards, the rules for the rule for the waiver and modification of student loans, the EPA's Waters of the United States rule revisions, the trade tariffs on solar energy materials, and some ERISA ESG regulations. So as you can imagine, just given the current makeup of Congress, where you have a Republican House and you have a Democratic majority in the Senate, but just by slim margins, where Senator Manchin of West Virginia, a Democrat, has particular sway over the ability to with potentially pulling along a couple additional Democrats to create a majority vote on some of these disapprovals. We've actually seen the House and the Senate come to an agreement that some of these rules ought to be disapproved, and in fact, the president did veto them, and without the ability of Congress to sort of override a veto with a supermajority, these actions sort of died on the vine. So you probably might be asking yourself, well, so why does Congress, why are they taking this time to take action on these disapproved these motions of joint disapprovals if they know that the president is just going to veto them? Well, a lot of this is about messaging, right? So Republicans in the House particularly have all long been on a platform for pushing back on the Biden administration's regulations. So this is a way to take a vote and publicly disapprove of a particular regulation. It could also put some of the onus on some of their Democrat colleagues in the House to try to demonstrate that particular members who may be in a red district, for example, but they are a Democrat, to put a tough vote on their plate for future election purposes. And then in the Senate, of course, it's kind of the same thing. These are a bit of a messaging bill. And they're putting pressure on the Biden administration to say, well, we, in particular Senator Manchin, who has had some at times contentious relationship with the administration, he's putting them on notice that he does not approve of the Biden administration's regulations, and of course he is a key vote, and he is in fact a chairman of the Senate Energy Committee, so he's an important senator. So that's why we are even though the members know that these actions will not be successful in this Congress, that's why we are seeing these Congressional Review Act disapprovals move forward, even though folks know that they are likely to fail. And in fact, besides the 5 disapprovals that were approved by both chambers of Congress, there have been a number of other disapprovals that have only passed the House. And there are actually some really interesting trackers on the internet that and folks who are taking a hard look at these things. And I'm happy to send those links around if folks are interested in just seeing which of the rules have been had disapproval motions in the House. So now we're going to turn to looking toward 2024. And so heading into 2024, there is this opportunity for the carryover provision to kick in. So again, just to reiterate, these are regulations that are submitted to Congress within the last 60 days of session time. And so what is the last 60 days of in session time in 2024? Well, it's highly dependent on the congressional calendar. And based on previous history, it's approximately any rule submitted to Congress by, I would say, May of 2024 is likely to start to be in this vulnerable period, because if you look back historically at the calendars, particularly in a presidential election year, that Congress is not in session for a long period of time. So, for example, they take off August recess. They tend to take off long periods of time in October, particularly right before the election. And you remember, all of the House members are up for election in 2024. A number of the senators are up for election in 2024 as well. So they want to be back home in the district campaigning. So the amount of in session time starting in about May tends to be a very small amount of time between May and November. And then they usually come back and do work in the latter half of November into December. So there really are not very many days that Congress will be in session. And so we'll be looking very closely as the House and Senate release those calendars, either likely at the end of this year. I would say probably within the next few months at the end of this year, we'll start seeing some of those the calendar and getting a better sense of how many in-session days we can anticipate in 2024. And so also what we need to be looking at is what can slow down the rulemaking process that would potentially put the rules into this category. So when you're headed into an election year, particularly a presidential election year, there are a lot of federal agencies that are working to not only put out proposed rules, but also finalized rules. So the Federal Register gets backlogged. And in order to finalize a rule, it must be published in the Federal Register, and it must be submitted to Congress. So those two things have to happen in order for the administration to finalize its rule. Things get backlogged. When I was working at the EPA in 2020, the Federal Register was slammed with rules that the administration was trying to get out the door. And so, the agency was sending final rules over, and it would be weeks, maybe even months before they were actually published. And so that's something to keep in mind. Government shutdowns. We're all talking right now in September about a potential government shutdown starting at the end of this month, beginning of October. Now, if the government shuts down for a significant period of time, the federal agencies will likely see a significant amount of their workforce that will be furloughed and unable to work on some of these key rulemakings. So if you think about it this way, if you've got a rule that was proposed in, I would say, in 2023 and in sort of the latter half of 2023, the last 6 months, there's thousands, hundreds of thousands of comments that have come in. There are career agency staff that are reviewing those comments, that are working on revisions of the rule. If they are furloughed for a significant period of time, that will slow down the rulemaking process, and could very well put some rules on a trajectory to start falling into this category of vulnerability. And then finally, congressional oversight. In my experience, working congressional oversight, both from the House of Representatives and then on the other side of the table at a federal agency, when Congress starts asking questions about rulemaking in the rulemaking process, things slow down. If you have to send critical federal agency officials up to the Hill to testify, yes, that might take, 4 hours of one day, but the amount of preparation work that goes into preparing those officials for the testimony on the front end is significant. If you're having to respond to congressional requests for documents, someone has to review those documents before they go out the door. If, in particular, if Congress subpoenas the documents, now there's, potential threat of litigation if you don't start providing those documents. Congressional oversight slows down the rulemaking process. And so that is something that we are also watching as we are considering the rules that are likely to be finalized in 2024. So what are the rules that are potentially vulnerable to the CRA look-back scrutiny? I think certainly the EPA power plant rules. The comment period closed in August. And they say they're going to finalize, the EPA says they're going to finalize the rule by April. That's really close to the potential deadline. And in fact, EPA pushed back on members of Congress and the regulated community and said that they gave an extra 15 days of commenting period, but this is a very, very extensive rule with lots of comments. And under normal circumstances, they may have given more time, but they didn't here. And I think in recent reporting, one of their concerns was leaving this rule vulnerable to the Congressional Review Act if the rule comes out too late in 2024 and if there's a new president. There's also a number of DOE energy efficiency standards. They've been working very hard to push out some of those rules, but there's been a lot of proposed rules here in the latter half of 2023 and likely into 2024. I think those can be vulnerable. NEPA Phase 2 regulations, rather extensive revamp of those rules with potentially lots of comments have here come out in the, again, latter half of 2023. I think some of the methane regulations, in particular pertaining to the Inflation Reduction Act, which created, for example, the methane fee. EPA still has not promulgated any of those regulations. We anticipate them, or they haven't even issued, the proposed rules for many of those. So we potentially see those coming out sometime this fall. And so, this starts to really, turn up the heat on the agencies to say, are they going to be able to finalize those before they become vulnerable? So really, it's any rule, I would say, that we've seen come out in this, or has been proposed in this latter half of 2023 into 2024. Those are the ones that we're going to be looking at to be potentially vulnerable. And this, really could have the impact of actually, removing some of those rules. And in fact, again, preventing the federal agencies from doing a substantially similar rule. So the impact is great. And it really can be difficult for the federal agencies as they're struggling and rushing to get some of these key policy movers out the door in this administration. So we're going to keep looking and keep our eye on how the interplay of the Congressional Review Act will be with the end here, potential end of the Biden administration's time. Of course, if there's not a change in presidential administration, I think the Congressional Review Act, we will still see lots of movement on joint resolutions of disapproval, but they're not likely to be signed into law by a president unless there's a change in administration. So with that, I am happy to answer any questions that you may have. If you would send me an email or give me a phone call, I'm happy to talk through some of the nuances of the Congressional Review Act or any of these regulations that we've talked about today and how we sort of see the potential implications for them moving forward with a potential change in presidential administration. So I thank you very much and have a great day.